The 1050 docket for Monday, October 24th, 2022 consists of one case. Appeal number 121914, State of Kansas versus Joseph P. Lowry, Shawnee County, briefs both sides.
Good morning. May it please the court. Shauna Miller on behalf of Joseph Lowry, the appellant.
May it please the court, Chris Elsleger, Deputy Solicitor General on behalf of the state, ready for argument.
Your Honor, that's the only case for this docket.
Okay, thank you, Mr. Shima. Counsel, you may come forward and 121914, State of Kansas versus Lowry. Before we begin, ask counsel to come to the lectern. I would note that Justice Evelyn Wilson has recused from this case. That means she will not participate in today's oral argument, nor will she participate in the court's conferencing of the case or in making of its decision. That, Ms. Miller? Would, just for clarity of the record, please restate your appearance then.
Yes, may it please the court. Shauna Miller on behalf of Joseph Lowry, the appellant. I would like to reserve 3 minutes for rebuttal, if I may.
3 minutes reserved. We'll go ahead and do it that way. Since no, that's okay. We're all getting used to this new.
May it please the court, Chris Elsleger, Deputy Solicitor General on behalf of the state.
Good morning again. I would like to start just give you a brief summation of the facts, although I know the court's very familiar with it. I think our audience might enjoy it a little bit as well. Also, in addition to that, I will be arguing the issues as raised in my brief, whatever ones I can get through this morning. So, Your Honors, this is, to say the least, a very bizarre set of facts underlying this case. Back in March of 2017, Shawnee County law enforcement discovered 3 bodies in a basement in Northwest Topeka. During the course of the investigation, as well as the trials that commenced thereafter, there's multiple different witness accounts, both eyewitness and otherwise, with varying version of events. And so this is kind of a very interesting case just because there were so many co-defendants, so many different kind of accounts of events in this case. Long of the short of it, though, ultimately, 4 individuals were found legally responsible for these homicides. The actual individual who we believe, based on the evidence, did the physical killings was a Joseph Cron. But there was 4 other co-defendants, Mr. Mays and Mr. Flowers and Ms. Lyles, and then of course my client, Mr. Lowry. And we are here today to argue Mr. Lowry's case in this situation. So as the court's aware, 2 of the victims in this case were killed by ligature strangulation. One of the victims was killed by suffocation. And oddly, the nature of death was not a controversy in this case. It was essentially a legal responsibility case in that Mr. Cron was found actually responsible for the killings, but the other co-defendants were found guilty through more of an aid and abet type theory. Some of the issues that Mr. Lowry addresses in the appeal in this case is one specifically whether or not the court erred in not giving him his voluntary manslaughter lesser included jury instruction specifically as to count 6. Now, voluntary manslaughter, of course, is not legally appropriate when it comes to certain crimes, such as example, first-degree murder. However, it can be legally appropriate in certain situations. It's in our argument that this particular case, as to count 6, it would be legally appropriate. And that would be due to the death of victim Davis. The circumstances related to his death is that he actually tried to escape the situation in this house. And it's Mr. Lowry's contention that it was his attempted escape that brought about this factually appropriate request for the instruction, was that The killing was done as a result of a heat of passion. It was not thought through. It was sudden. It was emotional. And Mr. Lowry believes that the factual scenario given rise to the killing would make it appropriate for him to request, and the court should have given the voluntary manslaughter instruction related to count 6 in this case.
Can you just kind of walk me through that for a minute?
Okay.
I'm having a little bit of trouble. So, someone is trying to escape,
Yes.
and so that brings on emotion. So he kills him because he's emotional that he's trying to escape.
Right. So one point of clarification, Mr. Lowry did not do the actual killing. Mr. Cron did, as far as physically. Now, obviously, we're dealing with the aid and abet theory. From various accounts on this case, was there at that time any sort of premeditation or thought process to kill Mr. Davis? We don't believe so based off the evidence. Mr. Davis, by his attempting to escape, caused panic in an already very contentious, hostile situation. But it was by Mr. Davis causing this panic of specifically Mr. Cron that caused Mr. Cron to tackle him, subdue him. Based on some witness testimony, Mr. Lowry assisted in restraining Mr. Davis. And then it was actually Mr. Cron that ended up killing Mr. Davis
How did
as a
he kill
result
him?
of that. I'm sorry,
How did he kill him?
by strangulation with an electric cord.
So you're saying there's no premeditation there?
I think based off the facts as they came in at trial, that it was reasonable for Mr. Lowry to at least request that lesser instruction. I'm not saying that the jury would have decided necessarily one way or the other, but that it was both legally and factually appropriate on that count based off the underlying facts for Mr. Lowry to request that instruction and for the court to grant it. Moving on to the second issue that Mr. Lowry raised in this case was the admission of various gruesome photos. And this was an issue that was brought up in some pretrial motions and was analyzed by the court. And there was a written ruling related to that analysis. And I guess a couple of things that I find particularly problematic is that, obviously anytime when you're dealing with a homicide, you're likely going to have gruesome photographs. That's just the nature of the underlying situation. But with this particular case specifically, there was no disagreement per se as to the cause or nature of death, as I indicated by either strangulation or suffocation. Yet over the defendant's objection, the state was allowed to introduce numerous photos, specifically, I believe, to victim Davis. There was numerous photos of just the facial area, which of course was extremely gruesome in nature. There were some physical injuries. There's a couple of photos with him still have the ligature around his neck, extremely disturbing. And it's our contention that while one photo may have been appropriate, certainly introducing several photos was not appropriate and caused ultimately the jury to be very disturbed by it. And again, the testimony was extremely disturbing related to this case. The medical examiner testified in detail as to the nature of the deaths. I believe the medical report or the report was introduced at trial. And so there was really no reason or furtherance by the state to introduce so many gruesome photos related to the death of these individuals. And so ultimately that did have a prejudicial effect on the defendant's trial in this case.
Your argument, the cumulative effect as opposed to any particular photograph, because I didn't really see fence drilling down saying, well, this batch is okay and this one's too much.
Right. So specifically, it would be the autopsy related photos. There's a couple of photos from the basement, I believe exhibits 33 and 34. And while those are disturbing in nature, I can see where the state would have some reason to want to display where the victims were when they were initially found. But it's the multiple photos of specifically, I believe, again, victim Davis of there's, 4 or 5 photos of essentially the same thing, just depicted at slightly different angles. And again, these are extremely gruesome photos. And so it's our contention again that while one photo may be relevant, that when you start introducing 3, 4, 5, especially when it's the same depiction, essentially just at different angles.
Counsel, why if the photos are the same, why are 4 more prejudicial than 1 or 10 or 20 or whatever?
Well, just human nature of having to see photo after photo after photo after photo. And they're the same, but there are different angles. So for example, the front side, back side, or just slightly different.
But if they're different angles, then they provide a different relevance to the case. I mean, that seems to me the tension at the heart of these photograph kinds of claims is if they're cumulative and repetitive, I have a hard time seeing how that enhances the prejudice. But if they're not cumulative, then why don't they come in?
Right. So again, even though the photos are the same or similar, having to publish those photos in front of a jury again and again and again and again just re-evokes those emotion that the jury is seeing. And again, I know the court, either has or will review those. They're extremely graphic photos. And it's just human nature when seeing something like that
It's a
over and
gruesome
over.
crime. That's
I'm
what-
sorry.
It's a gruesome crime.
Absolutely, absolutely. But there's other ways to depict and present the evidence other than just relying on cumulative prejudicial photos. And if the nature of death was a controversy, yes, photos can be very valuable to explain the manner of death, but that was simply just not controversy in this trial.
Counsel, can I ask you, it appeared to me, though, that the medical examiner walked through each of the photographs and sort of provided that sort of very clinical explanation as to each of the depictions and what the examiner was seeing from their perspective. Doesn't that sort of cut against the prejudicial impact argument when you couple the medical examiner's testimony with those photos?
Yes and no. If the medical examiner was describing different injuries, so, an injury to the chest versus an injury to the face versus an injury somewhere else, then possibly yes. But when he's describing essentially the same injury over and over on different pictures that are very, very much the same, I think, again, you get into the prejudicial area. Secondly, again, the nature of death is not argued in this case. We know that how they died through the strangulation. And so while that may be important in some cases, for example, we don't know which stab wound was the fatal stab wound, so you show various ones. That's just not the situation in this particular case. All right, I have just a few more seconds, but I'll move on. I'm actually going to skip to the last argument, which is cumulative error in this case. So I'm asking the court that even if the court doesn't find that each of the individual issues that I raised in my brief to be inappropriate, I would ask the court to find that based off the cumulative effect of the various errors that we've raised, that Mr. Lowry certainly did not receive ultimately a fair trial, that this cumulative effect of the errors could have affected the outcome of this trial very significantly. And I would ask the court to find that even though the evidence could be overwhelming, I think that if the court had given the lesser included instruction, if the court had given the compulsion instruction as requested by Mr. Lowry, and if the court had limited the gruesome photos in this case, that even though the overwhelming nature of the evidence related to certain other co-defendants, the outcome very well may have been different for Mr. Lowry. So I'm asking the court to find on that issue as well. And with that, I will turn it over to counsel.
May it please the court, Chris Slager, appearing on behalf of the state. From my point of view, this case is actually relatively straightforward. It's here because it's a murder case, not because there's any novel or particularly challenging issue. I think the law and the facts are pretty clear. With respect to the requested voluntary manslaughter instruction, the district court was correct to deny it. All of the evidence here pointed to the fact that each of these murders was intentional and premeditated and very methodically, or they attempted to methodically carry them out. Luke Davis was the first victim. They placed each of the victims in what they call the swivel chair, and then placed a plastic bag over their head to attempt to suffocate them. And I think that's pretty clear cut, intentional and premeditated. The fact that Luke Davis attempted to fight his way out, it wasn't just going to sit there and let them suffocate him, does not suddenly transform that attempted premeditated murder into a voluntary manslaughter heat of passion murder. I mean, Mr. Lowry already had formed the intent, along with Mr. Cron, the intent and premeditation to kill each of these three individuals. And the fact that while he was attempting to carry it out, that one of the victims tried to fight his way out, doesn't suddenly transform it into a lesser crime. That makes no sense at all. And of course, the voluntary manslaughter instruction would not apply at all. So the felony murder of Ms. Fisher, and then Mr. Levitt's situation was the same. He had also attempted to fight his way out from what was clearly the third in a pattern of intentional premeditated murders. So I would submit that there was absolutely no error on the part of the district court there. With respect to the photos, as I point out in the brief, it was not clear exactly, the appellant didn't specifically identify specific photos that felt were objectionable or too gruesome or cumulative. But looking at the record, there were a number that were objected to. And so as I submit to the court, those that were not objected to, of course, were not preserved for appellate review. And the ones that were objected to, if you look at the record, the district court analyzed each of them and came up, found a reasonable reason that the state wanted to present them, found that they were all relevant and not cumulative. I think at one point the judge said, look, just because they show the same picture more than once doesn't make it cumulative. It's just useful for different people's testimony. All were tied to the testimony of either the crime scene investigator or the coroner or one of the other witnesses. And looking at them, gruesome is, I suppose, a subjective term, but there wasn't anything particularly gruesome about these photos. I know I've seen much more gruesome photos and this court has as well in other cases. I don't think you could look at these and say, oh, these are just over the top gruesome. I mean, they were relevant to show the position of the bodies as the police found them. They were relevant to assist the coroner in his testimony. So I think it's a stretch to suggest that they were gruesome or cumulative. And then finally, on the matter of compulsion, of course, compulsion is legally not a defense to murder. So to that extent, it just doesn't apply. So the district court was correct to deny it on that grounds. As applied to felony murder, there were alternate counts of felony murder here. It would only apply if compulsion would negate the underlying felony. Right. And the logical problem that Mr. Lowry has, he claimed that he was afraid of Mr. Cron, but when this crime started, Mr. Cron wasn't present. Mr. Lowry and Mr. Flowers took Levitt and May's prisoner, kidnapped them, forced them in the house. And then Ms. Fisher was already there, and it's unclear. At some point, she, of course, was being held against her will. But again, that was all before Cron arrived. So the idea that he was afraid of Cron and that he should have got this defensive compulsion to negate the aggravated kidnappings is a bit illogical and nonsensical. And therefore, as there was not even a single error, there's no possibility for cumulative error. You have to have at least two errors to accumulate. There was not even a single error in this case. So if there are no questions from the court, I would simply submit that the district court got this correct and ask the court to affirm the convictions. Thank you.
Just very briefly, to address the cumulative argument, counsel is correct that, the compulsion argument, counsel is correct, and that is not a defense to murder. And as stated in our brief, that is a defense, in this case, could be a defense to the aggravated kidnapping. So just clarification on that issue, that could have been a argument or an instruction that could have been given by the court. And in fact, one of the co-defendants, Mr. Mays, exactly kind of the same underlying situation where he could have argued compulsion as a defense. And I think the state recognized that as well, that he was in the middle of a situation and he articulated that Mr. Cron clearly was the one who was in control in this situation. There's other testimony from other witnesses that indicated that Mr. Cron was the one that was really running the show and that other people were fearful of him. So it's our contention that it does not take much to allow a defendant to request that instruction, and that it should have been given related specifically to the aggravated kidnapping charges in this case. So unless the court has any other specific questions, that was the only other issue I wanted to address. All right, thank you so much for your time this morning.
Thank you to counsel for your arguments in this matter. Again, we will take this case under advisement.